Hello, fellow Toolboxers. Welcome to episode 314. One of our favorites, Kevin Gregg, is here to talk about the last 30 days of immigration cases that are coming out, plus a lot of stuff he's doing on the internet, on the national bars and stuff and events. We'll talk about that. I'm going to be at the AILA conference this June, so meet me there if you're coming. Let me know ahead of time so we can make sure we schedule a time to meet. Also, for those interested in marriage immigration law, learning consular processing, adjustment of status, I have the course for you, best one out there. Just contact me or go to immigrationlawyerstoolbox.com, see the course link. It's going to really game change your team, yourself. If you're going to practice or you're training people, it just does the job for you, so you don't have to worry about that. I also want to thank our great sponsor, Serenade. Serenade's e-immigration. They're going to be at the conference. They're going to have a lot of booth space there. The CEO is going to be there. I'll reach out, talk with them. I'll let them know you heard them from here too. That's always helpful. But it's going to be a lot of fun over there. I'll probably be at the booth a couple of times a day visiting them because I'm good friends with them. So really nice people. Hopefully I can catch you there. Again, the Serenade e-immigration. It's been going on. They've been around for a long time, so at the software. But it's won on awards, top ones out there when we do these reviews and rankings. Not only just third-party ones, but even for our own, interest groups and stuff. They know that this is one of the softwares that stood the test of time. So I appreciate their help and support. Having said that, none of the information here is intended for individual legal guidance. Please consult with a private attorney. It's really for immigration lawyers and paralegals discussion, primarily immigration lawyers. Having said that, I just, Kevin, thanks for coming on the show. I decided to use one of these softwares on Zoom where they like follow you, like they take notes and stuff. I'm hesitant to do it in consultations yet or per se, but for team meetings, I'm like, oh, this is good. It takes notes and we'll see what it does.
Yeah.
Immediately down 4 at the same time, and they're all running when I'm running Zoom. But they send me these reports. They say, "Oh, you talk too fast. You use bad language here. Like you said too much here." I'm like, "Oh my god, it's pretty immediate." It's amazing how they analyze, and I could make corrections and be more conscious of things. But thanks for joining, and good to see you again.
Good to see you too. I got a few things. You definitely talk fast.
Yeah.
As someone who has edited your interview on my show, you're fat. You got a lot to say. No, it's not. It's better than that. I guess talking slowly because people just can't. They just can't.
It bothers people a lot. I at daily basis, people say talk, and I do my live show. I'm in an hour, a daily basis on my podcast. Everyone's like, "We're foreign. We can't understand you." Comments, everyone, my family and stuff, and that's it. It kind of sounds crazy, but when I was 18 and stuff, I was so shy that I would start talking out loud to practice speaking, just because I was not functioning communication wise. I was so shy. And then so people catch me talking out loud, think I'm crazy. It was like, no, I'm just trying to be able to speak and without mumbling and stuff. And then it went too fast. And now I talk out loud. My wife sometimes gets scared. I'm like, no. In my head, I'm talking so fast. I'm forcing myself to slow it down and say all the words. It helps me to think better too, because I miss less stuff when I do that. But
This is the slow version.
Right now, today I'm hyped up. I had coffee for this, and I've been up since 4. But the reality is, I've been sick for like 3-4 months. In the last 2 days, I started feeling healthy again. I'm just like, hallelujah, God, I'm back. Like, I could actually do a podcast. I should do some casework and run my business. So I think I'm just high off, but feeling good. And tomorrow we'll see what happens. But I consciously have to slow it down. That's very important for my life. So,
do you speak Farsi, and do you speak this quickly in Farsi?
Yeah, that's even probably faster, and
Wow.
and that's my second language, so I say the words wrong anyways, and I say them wrong but fast, so it makes it even more confusing.
I must love that.
It's my family. My sister's like this too. I listen to the podcast at like 2.5x. Like it's too fast. It's too slow for me. I just like getting the information, getting out. But I realize I don't know how much deep I want to go conversations, but there's value in being fast. There's value in being slow. Like when I drive places, because the car is going fast, I only get to know a neighborhood so much. But when I ride a bike, I need to know it deeper because I see every store. And when I walk, I get to see each person going in and out. So it creates different perspectives, speed and time and speed. It's kind of like goes to the physics and stuff. Depending on how fast you're going, you get a different perspective of reality. And so when I do slow down, it gives me extra insight. When I do fast, it kind of calms me down because I'm getting all the information out. And because it's in my head, I want to get it out. I'm excited. But I realize it's too much information too fast. So it's not worthwhile. It calms me down, but it transfers that energy out to the other person because they're just trying to figure out what I'm saying, especially because sometimes I mumble. So I'm having a psychiatrist session out loud. But these are the things I deal with on an internal basis. I'm like, how do I become more effective in life? And this is one of the things I
enjoy it. Thanks for coming to my psychological session. Another thing though, before we get started, I do this. Everybody does this. It's becoming a pet peeve of mine. You introduced me, as one of the favorite guests that you have on the show. I feel like, and maybe I'm not your favorite guest, but maybe I am because I think I come on more than anyone. And
Yeah.
I feel like no one ever in any context ever ever definitively says something like everyone, or maybe it's a lawyer tell, like we always say, one of the best, one of our favorite, one of the best arguments ever made, one of the best basketball players to ever play. Nobody ever says the best or the worst or anything. We always qualify it. And I feel like people say it and they have no one else. I think we should just go in and say what we feel and say this is the favorite guest of the podcast if it's true, because then it leaves people wondering who else is out there.
Well, you're the favorite. I mean, this is. I don't mean as a backhanded compliment, but the practice area you talk about in these podcasts are the last thing I even want to think about. The fact that I do every month for how many years now, it's probably more testament that I like talking with you. And when it hits a certain case that I like, it goes within my wheelhouse. I'm like, I get excited. But the rest of them, I'm like, okay, removal. I understand the importance of it, but it's for me like, okay, I'm never gonna use this, but I like talking with you. I like talking with colleagues. So you are the best one. Yeah. Look at 2, 3 years. How long we do this together?
I don't know. I was gonna say after a year and a half, 2 years, I actually do see in your eyes when sometimes you're like, okay, just let him talk. I'm not really paying full attention. actually, I don't mind at all. I mean, that's the point of this. But also, if I'm not the favorite guest, that's perfectly fine with me. I'm just trying to, I guess, to change society, to really going all in.
You also want to make peace in the Middle East, or what?
We all just get out of ever having to say anything by saying one of the best, one of the favorite, one of the least favorite. Let's just go all in. Speaking of which, Bristow v. Mayorkas. I start off with this because it's right up your alley. Even though it's March 28th, I didn't get to it until April, and it's a district court case. We give props to the attorneys from the get-go. Brian Green, who I know very well, and Michael Jarecki, who I don't, but I'm sure is a great attorney as well. And it's an I-130 denial that they brought in federal court to challenge, and they won. And those aren't easy to come by. It was a sham marriage, and they got a big district court win in the Northern District of Illinois based on Seventh Circuit case law. So I thought it was pretty interesting, especially because you do these type of cases yourself.
So fill us in. What were the facts?
Well, Mr. Bristow is a U.S. citizen, married to a man named Felix Berto from the Philippines. It's a gay marriage, but Felix Berto has a child in the Philippines, I understand from the decision, with a woman, naturally, and 2 prior marriages to a woman. So, sexual preference is complicated, but we all know that USCIS likes clean. This is far from clean. The first marriage was denied. His first wife, Marilyn, filed an I-130 petition for him, which was denied. They didn't make a fraud finding, a 204C finding back then. Then he marries another woman. They don't file anything. They're together for a long time. And then eventually he marries Mr. Bristow. And when Mr. Bristow's marriage is completely legit, everybody agrees they're married. It's bona fide. But they made a 204C finding, which is just kind of cruel, to be honest with you, for the first time when adjudicating this I-130 like 15 years later.
This is something that I want to strangle somebody. I get these where they're like, yeah, bring evidence from 2000 that the marriage was valid. Like, that's 20 years ago. I hate this person now or something. I divorced. I don't want any paperwork from them.
Hey,
it's so unfair.
Bring the hate. I'll take the hate. You don't hate someone where it wasn't a valid marriage, right? I'll take it. I love the hate.
So tell me about this case. So what was, because this is a major issue, because when we have people from marriage cases to come in, we analyze the previous marriage. And they're like, why are you going after? I don't want that. I'm like, no, we got to get into that, because they could hit you if you have an I-1. Even if you didn't go through the case, let's say you withdrew it because marriage fell apart, they're going to still look at that as marriage fraud if they want to. It's really ridiculous.
Now, immigration never forgets. It's a terrible thing. But the good news, as you know, is with a 204C finding, when you challenge it, or even when you don't, but if you're not challenging, it's just USCIS's world, it is USCIS's burden. And the government bears that burden. The USCIS, or in federal court, you're suing USCIS. It's got to be based on substantial and probative evidence that the marriage was entered to evade immigration law. That's the standard. It's a high standard because this is a permanent forever bar that bars immigration of valid marriages if it's based on a prior fraud finding. And how about this? Now, this is only from the Seventh Circuit, but I imagine there's this quote in a lot of circuits, quote, a good faith marriage motivated only in part by immigration benefits is not illegal, end quote. I mean, and quite look, I mean, you'd be crazy, right, to marry a non-citizen and not be thinking about immigration.
Yeah.
Like it's gonna play a part. Like you want to help your spouse. That doesn't make it fraudulent. Here it seems, and the case, it's a district court case, and fact finding with district court cases is sometimes weird because the judges are sometimes just trying to, like, get through their docket as fact finders. But so Brian Green and company bring an APA challenge to the I-130 denial, which, to get into the weeds and make your eyes glass over, all the Patel litigation and the fact that USCIS doesn't have, that the federal courts don't have jurisdiction and blah, 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 that's based on adjustment of status, I-45. A standalone I-130, though, there is no case law yet that I'm aware of precedentially saying that courts lack jurisdiction to review this. That's just a straight Administrative Procedures Act challenge over an agency decision, not tethered to any discretionary relief. Approving or denying an I-130 is not discretionary. It's just, are you in a valid marriage or not? Or in this case, was the prior marriage not bona fide or not? Caveat, I believe the Supreme Court granted cert on an unpublished 11th Circuit decision last week for next term, in which I think the 11th Circuit, in an unpublished decision, so who gives a shit, said that there wasn't jurisdiction over this. So I do believe the Supreme Court might be primed to determine whether there's jurisdiction to review this next term. But I don't want to be optimistic. I went to an FBA conference and said Patel was going to come out the other way. So God, who cares what I have to say? But I can't imagine anyone except Justice Alito saying that there is no jurisdiction to review USCIS's denial of an I-130 or revocation of an I-130. It is completely separate from adjustment of status. In fact, immigration judges, as you know, have no jurisdiction at all to decide or deny an I-130, which is also absurd.
Appeals go to BIA, right? If I-130s, they go like that. Some weird EOIR.
Yes. Well, you don't have to. I don't think they did so here. I don't count me on it. And if you do it and you have malpractice, sue John Khosravi. But I don't think you have to go to the BIA to exhaust your administrative remedies. I think you can bring an APA challenge immediately, but I'm not sure. Either way, here it happens a lot. I mean, there's some that looks like interview notes from Maryland way back when they Stokes interviewed him, in which the officer's notes indicated that Maryland said it was a fraudulent marriage or something. But these officer notes are not verbatim. And at this stage, at least in response to the Noiter RFE, they come in with a sworn, detailed affidavit from Maryland saying, no, I never said that. It's a completely valid marriage. And so now, essentially, to the federal district court judge, you have USCIS faced with some non-verbatim officer's notes from God knows when, an innuendo, and a sworn affidavit and other evidence as well, multiple sworn affidavits, but one from Maryland. And USCIS can't do what it always does and just say, we believe the officer notes from way back when. You can't just ignore a sworn affidavit, especially when USCIS has the burden by a preponderance of the evidence. It's their burden. Even if those two things are equal, they still lose. And how can it anyway with a sworn affidavit? They can't just say, well, that was created after the fact. An affidavit's an affidavit. Either it's credible or it's not. And if it's not, I mean, there is non-immigration precedent in every circuit about when an adjudicator can disregard a sworn affidavit. Now, assuming it's a sworn affidavit, get it notarized or use the penalty of perjury languages verbatim from the penalty of perjury statute. But, quote, the evidence of fraud must be relatively high to trigger 204C because the consequence of engaging in marriage fraud is a permanent bar to any visa approval. Most of the federal court cases addressing marriage fraud involve direct evidence of fraud, often a sworn statement admitting to the fraud that has not been credibly refuted or rebutted, end quote. That's a hell of a quote. Wish it was from a circuit court, but still good stuff.
But catching on this stuff, so that's good. These bad scenarios talking about. I just remember I had a case where the guy got his green card through marriage, had a previous one 20 years ago that he withdrew, and then I-130 whatever adjustment, and then got married 15 years later. Green card got approved. He fought for Nats, and then he got after 3 years, and he got a rescission notice
Yeah,
saying
yeah.
previous marriage was the first I-130 was fraud, even though it was never adjudicated. And this guy got a rescission. I was like, damn, rescission. And I studied the rescission statute. I'm like, this rescission is ridiculous. Like that's it shouldn't
Yeah, you
exist.
never file within unless it's been 5 years or more if there's a sniff of a problem before.
Exactly. Yeah. Yeah.
But you can't pick your clients.
So you got to analyze it, and that's the thing. Like, if you had company first, I was like, "Oh, you have this previous marriage, you have no evidence. Let's wait 5 years." Client doesn't want to hear that. It's like, no, there's no way they're gonna do something. But if everyone listening, man, it's USCIS. You never know
Just
what you're gonna
tell them to listen to my podcast. They'll just go through a horror show of bad
get. Yeah,
things that can happen to people. It's really what it is. It's like every week, it's like one good thing for non-citizens and like 2 to 7 horror.
Yeah, two. I wish it was just two. It's a bad situation.
Depending on the week. So again, Brian Green, Michael Dracki, great win for Mr. Bristow and Felix Bertho, and great win for us to remember.
And one thing you mentioned about I think you mentioned FBA bar. You're going to be speaking. Let's make sure we mention that you're going to be speaking at is it the FBA, the Federal Bar Association conference?
That's right, the immigration conference for the FBA in Salt Lake City this week. So you got to get this podcast out ASAP.
I'll get it ASAP. Where is it, in Salt Lake?
Salt Lake City. I can't stop singing the Book of Mormon song. I don't know if you're familiar with the show, but it's going on repeat in my head.
I haven't watched it. I know
called
it.
Salt Lake City. Friday and Saturday of this week. Really looking forward to it. I can't make the AILA conference. I've told you. I'm not sure if I said it on your show, but my wife is pregnant and due around the AILA National Conference, so can't go to that. Wish I could. It's a lot of fun, but the FBA conference is cool. I mean, I would do both if not for personal reasons.
How big is the immigration contingent growing to this FBA conference? Are you noticing increased numbers of people coming for our stuff?
Well, first of all, this is an FBA immigration only. I mean, I go to other FBA conferences. This is the FBA. This is the immigration law section of the FBA. I go to other ones. At the other conferences, I'm always like one of 5 immigration people.
Yeah.
Brian Green being one of the other 5 usually. My wife is involved in FBA normal as well, so that's why.
Mm-hmm.
But this is just all immigration folks. And the cool thing about FBA is that it's the only bar association where federal court employees can be members of. So especially the DC one last year, which is right in the backyard. I mean, that was full, and Detroit 2 years ago was full of government folks, ICE attorneys, oil attorneys, immigration judges, federal court judges, BIA appellate members. So it's cool in that regard, in that you can speak to these people and be collegial as we're supposed to be and make connections out of the courtroom, which is how all other areas of law do it. So why not us? And they're not allowed to go to AILA events, is my understanding, or if they do, they can only speak in their official capacity.
Yeah.
I don't think they can just attend. They have to be speaking. So it's a whole thing. But FBA, they can just, be members.
Well, cool. And you mentioned, Brian Green that did that case this morning. I woke up, there was a settlement that happened on this ICE OPT raid. And a shout out to Diane Butler. I think Jonathan Wasden may have worked on that as well.
I think they're on it. Yeah, it seems similar. Yeah, we did a similar one with the fraudulent school.
That was incredible. The
University of Northern New Jersey. It seems like they had a similar one, like all these sting operations, a fraudulent OPT program. I don't know much about it, but yeah, and it seems like they got a not just trying to promo Ira and Eddie, but it seems like their settlement was similar to the one we got, and that is how it should be. Like, don't hold a fraud finding against these people going forward, be it state or USCIS, if they, if they were entrapped and they really weren't, really weren't involved, and they weren't trying to do the wrong thing.
You make up a fake school. Foreigners have no idea what's going on. I mean, some of them they don't know what's going on. They say the teacher, school says the rules. Like, how do they know? I mean, they hire lawyers each time. They can't afford that.
I'd like to see one of these with Fine Dream. I don't know if you've ever seen Fine Dream. That's another lingering one out there. That's a huge problem. I don't think anyone's sued on, but we've had Fine Dream clients. I mean, Fine Dream was, at one point, it was like the second largest employer of foreign individuals in the country. Like, it was like Apple, Fine Dream, and Google. It turns out Fine Dream was like, their address is in a warehouse in Sacramento or something. And it was just, the whole thing was a front by a Chinese national on like an L or an F, I think. And she gets convicted in Chicago, and she just said all these people were, culpable, but a lot. And now that was like 10 years ago. And now a lot of these people are like high level engineers with like Google. And some of them thought that they were just doing an internship and that part of their internship was to do training and not work. It's a mess. Now, some of them are culpable. Some of them were paying Kelly Huang to file false tax returns for them, but others were like caught up in it, not knowing how to navigate the system. There's a lot of mess out there. But anyway, if you ever see Fine Dream on your client's history, your flags should be on fire.
Wow, that should be good. Yeah. Very interesting. Very interesting. And one, like, we got really picky on first day CPT, just at least knowing if the client did it in case they want to make a big deal of first day CPT again or something like that. I hate messing around with this stuff. People, I got a contact from a guy. He's like, I got several contacts for you want to do F1 visas and stuff. I'm like, it's good to have a lawyer for a visa to avoid this kind of stuff. Because people make mistakes, don't know who to listen to. They read stuff online, or even we have issues where they come to U.S. tourist visa and they decide to change status to F1. And if they contact the school and the I-20 is issued within 90 days, they'll sometimes get them for misrep for change of status within 90 days for F1.
Yeah, if they put Fine Dream or another one of these things in their DS-160 because they think they're supposed to list their prior employment when it was, I mean, that might get them for fraud, even though they were trying to comply because they just thought.
They don't know. I've been to internships in law school where I just sat there for 3 months.
Yeah.
So these are the things like, who's going to know this stuff? You have to have a lawyer that's really into this stuff to try to. I just Fine Dream things the first time hearing about it. I'm like obsessed with this stuff.
That's a big deal.
So hard, yeah. Well, I'm glad we got it out. See, this banter causes like important piece of information to come out. I love it.
On that, on the I'm always trying to give segues on your show, John. On the subject of crazy, unfair things.
He's on control, not yours. Let me go
on pages. Hey, look, what are you, two hosts talking? We're just gonna act like hosts. What do you expect?
So it's 22 minutes.
You don't know what I've got on deck, so I have all the cards. That's why.
That's true.
Chajati et al. V. Blinken. It's bad for non-citizens out of the fifth, but I think I'm just seeing this like as the circuit watcher I am. I think this case was filed by the same excellent attorney in like every circuit, and he just keeps losing. And it's not because his arguments are bad, but it's a difficult one. It's essentially brought on behalf of the Indian EB. I think it was EB3. I'm not sure. The Indians who they were current for like 1 month in October of 2022. Yeah. And then they retrogressed the next month, and they filed before it retrogressed, but then USCIS put this like administrative hold, and they've sued the Department of State and USCIS for this under the APA, and all the circuits keep saying we don't have jurisdiction, whether because of Patel or because it's discretionary to retrogress, or it's all tethered to adjustment of status. It's just a bloodbath on these cases. Another one is Stagula v. Jadot out of the 8th Circuit in March. So it's unfortunate, but there are some USCIS listeners to my podcast, and they have commented when I've talked about these is that, yeah, the administrative hold policy, even if we're not going to call it a policy from USCIS, sucks, but it does at least allow these people to be here with a pending adjustment of status application, technically, and don't quote me on it, I think that their derivative children will be Child Status Protection Act frozen.
There's potential for it, yeah.
And if that's I think it is. And if that's the case, and that's a big deal. I know that these Indian non-citizens want their green cards, and this is the weight is absurd. And it's Indians, because Indians are special because of how the visa bulletin works and the amount of Indian nationals. But so this decision keeps losing. I'm sure I'll do it again on the podcast. I'm going to just start quoting back to the other times I've done it, but
there's a minefield of problems coming from that one. One is we had cases where the family was on H4s visiting India, and then all of a sudden USCIS like adjusted the case and they're stuck outside. Now we have to IA-24s, and then visa bulletin retrogresses. So all of a sudden the kids are stuck outside. And it's like,
they were adjusted during that month?
Well, they had I-4 pending, and then the parents here, the family,
right.
husbands here, wife and kids go to India. Adjustment of status comes. The H4 is getting validated. They didn't have Vance Pro approved yet to have that.
Oh,
And then, okay, all of a sudden, 4 or 5 years, 6 years of your kids can't come to America for college
yeah,
anymore.
it's just crazy.
That stuff makes me want to throw out the way. And then the next level it is they started approving like EB2 cases as EB3, EB3 as EB2. And it's like, well, that wasn't current where they approved it. That was the wrong category. That's when they did like everyone do EB3. They're like, oh, everyone do EB2. They're that back and forth craziness of the last 2 years. And so there's probably thousands of cases that now USCIS is kind of taking it as like, we internally take the visa bulletin number. So even when we issue it, that doesn't reflect necessarily like when we took the visa number out. But that's just like a catch-all. Yeah, it's like whatever, we do whatever we want essentially, because I don't think I have any records of when they take this stuff out or way to look back, honestly. But for the ones like, so those are the horror stories. Then we have other people who have been current for a long time, like year now, and like nothing's happened. It's moving forward. They're like, I need to change my job. I'm afraid to change my job to will pay me well, or treat me well, all that kind of stuff.
Well, if they're in this administrative hold policy, which again might not technically be a policy, then then their employment isn't tethered to their H anymore, right? They could, if they get their 765 approved with their pending adjustment, they can do whatever they want. Mm-hmm. So if they did file in that like 1 month period, and it's pending, I do think that they've got some good benefits. Mm-hmm. But the whole thing is absurd. We had a lawsuit in the DC circuit trying to, on a reading of the INA such that derivatives shouldn't be counted in the country caps.
Yeah, it's the EB5 cases you guys are suing on, right?
It was the EB5. We lost it we went down in flames because it's a chutzpah argument, but it was not frivolous. But if they did that, who knows what other categories that could also apply to, and that would add thousands of numbers. And why not, John? Why not?
Oh, that's logical. Why not? But because all these bills that come up, this issue does come up. I think the courts could just say this is legislative branch stuff because it keeps being shot down. But the legislation is badly written. They leave it up to agencies. We'll see what they do with what's his name? Those court cases, Chevron deference and
Loper Bright, the fisherman.
Yeah, let's see what happens with that.
Bad law.
That could be a backdoor way to get it because from what I recall from the EB5 case you're suing on, the INA is not clear how they're counting these. So it's really a policy decision how they're counting these, right? Or is that what I was saying?
We will see if Loper Bright overturns Chevron. Then it is what? Then literally it's immigration like pre-dawn of time. Like immigration starts over in 2024. Like nothing matters anymore, and like it is the Wild West now. People are cynical, and like, will some circuits just say, well, yeah, no deference, but immigration has national security concerns, so it's not Chevron deference, but we do defer to the agencies? Maybe, but there's 11 circuits, there's 12 circuits if you include the DC circuit doing this stuff, plus the Supreme Court. And so much precedent relies on Chevron deference over the last 40 years in immigration.
Deep. They bring it up in AO decisions. They bring it up like it's Chevron deference.
So much. The whole concept of a particular social group is Chevron. It's crazy. It all blows up this month. And like I do these cases on the pod recently where like the courts are relying on Chevron. I'm like, I said it last week. I'm like, there might not be Chevron in next month when you issue your mandate in this decision. Like, why is anyone issuing decisions anymore? And that's just immigration. God help us what they're going to do with Loper Bright. Maybe it'll help non-citizens, but I am scared. And look,
it affects every context of our policies because everything was deferred agencies nonsense. So it's like,
if you can sue the EPA or one of the various or the SEC every time. If you're a $1 billion corporation, you can sue them anytime they do anything. Then they don't do anything, and we go back to the 1970s where they're swimming in sludge. But that's beyond the scope of this podcast.
It's one thing immigration that makes it hard and great at the same time is like we've been practicing for a lot of years. If this happens, we have experience on how to talk to clients in the law. But essentially equalize every couple of years, Trump comes, equalizes immigration. Because to figure out how to deal with Trump, like it's your new lawyer essentially all over again. So it keeps it fun and fresh, but a lot of pain because you got to keep learning constantly. It's not the same thing over again.
there will be so little precedent that can be relied on if they blow up Chevron. I cannot stress it enough. It's just crazy. Every case you'll be able to challenge, be like, well, this relies on this decision from 1994 where they were deferring. And so the Ninth Circuit only has this line of precedent because they deferred to the agency interpretation in 1998. So literally all the precedent relying on that precedent are no longer good law. I mean, it's impossible.
It's probably bigger than the NTA issue we always talk about, where if they reopen it, I mean, that's a big one, but like this is even potentially bigger.
I'm going to decide that this term. I mean, every term now it is just massive. I mean, forget it, Dobbs. Don't get me wrong, like Dobbs last year. I mean, and it's not just Dobbs. It's just every term there are these massive Supreme Court decisions. And it's because we're living through a reactionary Supreme Court.
And the I mean, Congress has not cleaned this stuff up on its own. So and then ends up falling on this kind of stuff. I don't think Congress is going to do anything with immigration either way. So executive does his own thing, which all Chevron's about. But I don't know. It's bizarre that these, people email you like, oh, it's just a form. Like law is easy, immigration is forms. Like, dude, this is the craziness. Like none of it makes any sense, and there's every year it changes. This is not an easy thing to deal with. All right,
there's a case before the Supreme Court this term that if the Supreme Court affirms the Fifth Circuit finding SEC judges unconstitutional, I don't know, who knows? Maybe immigration judges are unconstitutional. I mean, it is just and I'm stealing this from Strict Scrutiny, which is an excellent podcast of law professors, but like the Fifth Circuit is just funneling crazy to the Supreme Court every term now, and like, is the Supreme Court going to agree or not? And it is a very wild world to live in, and we're all just living in the Fifth Circuit and the Supreme Court's world right now.
Well, FTC just banned non-compete clauses. California already banned them. A lot of states did already, but they immediate lawsuits on that. That's going to go up to, and that's another agency. Could they even make these kind of big decisions like this? Right. So, just so the legal analysis side of immigration is amazing, like amazing in neutral terms. But then when it comes down to the immigration aspect, it's a brave new world. So go to your AILA conferences, study up on this stuff. You're going to have to be studying a lot as it goes forward and writing a lot probably.
Let me end on a good note though. And hey, Loper Bright might
be fun, yeah.
Loper Bright might be good for immigration. I don't know about the world, but
take we'll figure out the rest later.
Abdullah Hadvi Garland out of the Sixth Circuit, back to a standard asylum, this Convention Against Torture type case out of Iraq, about changed country conditions. Great win by law students, which is just awesome, from the University of Minnesota, with the help of Russell Bruton, which is always a good person to have help you. This is about cat protection. So even before the facts, the Sixth Circuit said in this decision, for the first time apparently, like all other circuits, that the Convention Against Torture analysis requires an aggregation of all sources of torture to see if it gets above 50% possibility. That wasn't the law in the Sixth Circuit apparently yet, but it is now after Abdullah had definitively. So, if you've got a bunch of sources and maybe all of them individually isn't more likely than not, but combined it is, then now how do you do that? I mean, that's all mush to me. A different Sixth Circuit decision this month, actually, where the non-citizen lost, came out and said, well, it's a holistic approach. You're not just like saying 15% because he's, a criminal, 15% because he's got mental health issues, 10% because of his politics. No, it's like looking at the whole person. And is it over 51% based on all the asserted sources? So that in and of itself is important in Abdullah had, but also for Iraqi asylum cases and change country condition motions to reopen. This guy filed like 3 or 4 change country condition motions to reopen. And quite frankly, probably the BIA probably just got sick of it and just started saying conditions aren't different from last time you filed your motion, bro. But that is never the proper analysis. The change country condition motion to reopen analysis is from the time of the hearing as compared to conditions now. Mm-hmm. And so really it doesn't matter what conditions were like in the motions to reopen in between the current motion to reopen and that first hearing where relief was denied. So when the board does that, when they say this is just a continuation from your prior motions to reopen, I mean, that is a black letter incorrect thing to do. That's what the Sixth Circuit is saying here. And by the way, quote, Christians have long faced discrimination in Iraq, end quote. But that's not a reason to deny a motion to reopen. Things can get worse. Some other good stuff in this by an entity that I didn't know of, and I'm not an expert in Iraq, but the Iraq's Popular Mobilization Force, or PMF, which it seems had something to do with getting out ISIS, but also apparently, according to the Sixth Circuit and the Department of State, they're also committing human rights abuses, targeting Chaldean Christians, becoming hostile to U.S. personnel and those who support them, as Iraq starts to gravitate a bit more to Iran. That's what the Abdulahad decision is saying here. And so big, important non-citizen win for a multitude of reasons.
I just had my head like some of these countries, and unfortunately, I've heard of Mexico recently, but Mexico, like people get drills in their ears and their head. Sorry, trigger warning, but it's like, damn, if I had to be sent back to deal with that, I'm like, oof, that's back for vacation. I don't go unless the border area is supposed to be dangerous. But
yeah, right. No, those tourists, right? 2 Australians and an American got killed in Baja last week.
Yeah,
I mean, I don't know. It looks like it might have been a robbery. Who knows? The world is a scary place, and these decisions. They get so wonky legally to see, well, if the scary world gets you relief or protection in America. I mean, that's what a lot of these cases are, but not all of them.
It's a lot of responsibility, like knowing your work, and sometimes nothing you could do, but like, oh, this person it could be sent back and they will die and be tortured to death. And it's like, whoa, that's like doing surgery, like life and death surgery on somebody. Requires a lot of courage and steady hand to go through that.
It's crazy.
Yeah, and you're doing those daily, so you're out there. Me, I help couples and I shepherd them along happily.
I mean, making sure that they don't have a fraudulent marriage allegation.
Yeah, those stuff. Or say just because they'll just come the wildest things. I've so many people contact me. They filed their I-64 incorrectly and got denied. I'm like, oh, dude, now you got to refile, and you may have been an LPR 130, so you know part of your day you're out of status. If you just click this right box, you would have been saved. So that there's billions of values, but I just emotionally can't take the toll of these kind of humanitarian cases. It builds up.
Well, I treat, I'm sure you get these too, like people who maybe they're in a marriage now and they entered as a tourist, but they filed an asylum application from, I don't know, Venezuela. And it's the same thing as a fraudulent marriage in their past. Like, you better make sure that they can talk intelligently about that asylum claim in their marriage interview, because that is equally at play. Everything is at play in these USCIS interviews. So
we prepped them for that. But I remember one lawyer saying there's like, because I don't do asylum, they're like, asylum's supposed to be like secret, not supposed to talk about it. Like I had one case where the guy was gay, and then like he met his wife, and she like, they're religious, and like, okay, we can't do that, like, and changed it up, and everything worked out. I just talked with him. I'm like, straight up, bro, what's going on? And he's like, no, how you get judged this kind of stuff. What I found in my marriage green card interviews back when I did interviews was when we had gay clients, same-sex clients go, like they wouldn't ask you anything. And they're just, okay, approved. Because I'm like, how do you, it's easier because I don't know, experience, or just because I'm married, like it's easier to judge potentially judge, and this might be completely untrue, but a heterosexual couple, because you're used to seeing and judging like the shiftiness of it. But as a same-sex couples, like I don't have a reference to even judge that, because their relationships could be, I mean, especially like it's going to weight politics right now, but I have same-sex guy couples and they have open relationships. And it's like, that doesn't mean relationship is fake. It's just because that's what that's their relationship. People, even straight couples have like mixed relationships of different kinds. So they're always worried if they get to get into it. But for me, they never get into anything when it comes to same-sex couples. I'm knocking on the wood and I'll keep that going. But it's weird.
Well, I can't speak to that, but keep rocking on.
I don't see because I don't know what happened. We have like a disproportionate number of same-sex couples in our office. I don't particularly advertise, and they're not necessarily referrals, but like they see my videos probably. So probably like anytime like a third to at least a fourth to a third of our cases are same-sex couples, and they're always really worried because it could be age differences, and then also like age differences they're really worried about. I never had issues with age difference, and then they're like, we do have like open relationship. I'm like, if they ask, tell them the truth. Like sometimes people get like prenups and they're afraid to tell. I'm like, people get prenups doesn't mean the officers could interpret stuff crazy ways. We battle that, but like people get prenups. It's not like it's not the law. So there's a law for it. So you shouldn't hide. You shouldn't stop your life because of USCIS.
Agreed. Out of the end where we started, a good faith marriage motivated only in part by immigration benefits is not illegal.
Exactly. Well, Kevin, thanks for coming on. I'm going to get this out soon so people will see you in Salt Lake. And hopefully there'll be recordings of it or something you can get out too. But if you want to reach out to you, Kurzban firm, obviously famous firm, but if you want to reach out to you directly, partner at the Kurzban firm, you're the West Coast office, so it's a big deal. K Greg, 2 G's at the end, kktplaw.com. Type in Kevin A. Greg, it'll come up.
That's right. Not my arch nemesis, Kevin C. Greg, who is also an excellent immigration attorney, and we just have very unfortunately similar names.
I guess I'd recommend go to Immigration Review Podcast. That's the best way, and we can find it wherever podcasts can be found. Thanks so much, Kevin, coming on again. I really appreciate it. I got another live. I got to go in 10 minutes, so I think I'll usually talk afterwards. I think I have to drop. We'll talk for a minute.
Don't go behind let the people think that we just go off and we never talk again. Don't let them know about the behind the scenes stuff.
Yeah, before or after we sit and talk. But I have like a live Q&A for my law firm. I do I take questions live. And I got 10 minutes to set up and really just get some water from my throat. But really appreciate coming on. We're going to get these out much faster. You probably don't notice it, but we were kind of a backlog because I've been sick and tired and everything. But now we're just going to go live and just plug it out like this, make it fast. So I appreciate everyone listening. We don't edit. We want to get you the facts as fast as possible. But this is not intended for individual legal guidance. Consult with a private attorney. It goes back to the beginning where he said, "Why can't we just say things for sure? Why do we always couch the terms that we use? We're can't help it." But I appreciate it. But stick around. I'm in the recording. Thanks everyone for joining. I'm going to be in AILA National. Check me out there. Check out the Marriage Green Card course. And thanks Sarah Nate Immigration for doing this. All right, everybody.